I recognize the Honourable Attorney General to move the second reading of the bill.
Thank you, Madam
Has there
Speaker.
been a change?
The Honourable Minister of Financial Services has conduct of this particular bill. Thank you.
I recognize the Honourable Member for Financial Services.
Thank you, Madam Speaker. Madam Speaker, I beg to move the second reading of a bill entitled the Proceeds of Crime Amendment Bill 2015.
The bill has been duly moved. Does the Honourable Minister wish to speak on it?
Thank you, Madam Speaker. Very briefly, I rise to present the bill on behalf of the government. It is a bill to amend the Proceeds of Crime law by deleting paragraph B of section 5(1) of the law and replacing it with a new paragraph B, which would read the chief officer in the ministry responsible for financial services or the chief officers designate. Madam Speaker, just briefly, the genesis of this is in connection with the establishment of the specific ministry and the change from the involvement of the financial secretary on the anti-money laundering steering group to allow the chief officer for the ministry to sit on that steering group in his place. And I would like to thank the financial secretary for the role that he has performed on that steering group. And certainly there will be ongoing opportunity for his involvement in these related matters. So with that and those brief comments, Madam Speaker, I commend this bill to this Honourable House for passage.
Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call on the Honourable Minister for Financial Services if he wishes to exercise a right of reply.
Thank you, Madam Speaker. Just acknowledge the support of members in relation to this short bill.
The question is that a bill shortly entitled the Proceeds of Crime Amendment Bill 2015 be given a second reading. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. The Proceeds of Crime Amendment Bill 2015 has been given a second reading.
The International Interest in Mobile Equipment Cape Town Convention Bill 2015.
Recognize the Honourable Minister responsible for Financial Services.
Thank you, Madam Speaker. Madam Speaker, I beg to move the second reading of a bill entitled the International Interest in Mobile Equipment, brackets Cape Town Convention, Bill 2015.
The bill has been duly moved. Does the Honourable Minister wish to speak to the bill?
Thank you, Madam Speaker. Madam Speaker, I rise to present the bill on behalf of the government. It is a bill for a law to repeal and replace the Cape Town Convention Law 2009 to give effect to the Convention on International Interests in Mobile Equipment and the protocol thereto on matters specific to aircraft equipment. Which was concluded at Cape Town, South Africa on the 16th of November 2001, and the declarations to be made by the Cayman Islands in respect thereof and for connected and incidental purposes. Now, Madam Speaker, this bill will introduce required legislation to give the Convention on International Interests in Mobile Equipment and the protocol thereto on matters specific to aircraft equipment, which I will refer to as the Convention for brevity, the force of law in the Cayman Islands. The Convention is an international private law treaty which is designed to standardize cross-border financing and leasing of high-value transactions involving movable property such as aircraft and the financing transactions in relation thereto, which often arise and utilize Cayman Islands vehicles. In particular, the aim of the convention is to facilitate the financing of the acquisition of aircraft, facilitate the utilization of asset-based financing and leasing of aircraft, and ensure that interests in aircraft are recognized and protected universally. And lastly, to provide broad and mutual economic benefit for all interested parties in relation to the financing, leasing, and utilization of aircraft. Madam Speaker, in 2009, the Cayman Islands enacted the Cape Town Convention Law 2009, which I will refer to as the 2009 Law, which was designed to give local effect to the convention and hoped to be an effective way to deal with the fact that the Cayman Islands was not a contracting party to the convention. So the 2009 law was a substitute, and it was hoped that that would be sufficient. Now, while that was welcomed by some, it did not provide the full desired effect, as many others, including important financing institutions and international or national export and credit support institutions, such as the U.S. Export-Import Bank, placed a greater emphasis on the fact that Cayman did not have international recognition as a contracting party to the convention. Therefore, the effects of the 2009 law were considerably restricted, and the success was limited. Consequently, Cayman vehicles have not been able to participate in a variety of transactions which otherwise might have been structured to include Cayman Islands business vehicles, but were instead being structured with vehicles domiciled in competing jurisdictions that are a party to the convention. So, Madam Speaker, the extension of the convention to the Cayman Islands is anticipated to have a significant positive effect on our aircraft finance industry by reestablishing the Cayman Islands as an attractive jurisdiction to aircraft finance investors and to their service providers. Madam Speaker, the bill is arranged into three parts. Part 1 deals with clauses 1 and 2 and addresses the short title and commencement. It defines new expressions and interpretations used in the bill which relate specifically to the convention. Part 2 includes clauses 3 to 5 and contains provisions relating to the convention having the force of law in the Cayman Islands, and the Cabinet having powers to amend or revoke the declarations to be made by the Cayman Islands in respect of the convention, which allows the Cayman Islands to amend or supplement certain provisions of the convention as it sees fit. It also provides that the Grand Court shall be the relevant court in the Cayman Islands for the purposes of the convention. Madam Speaker, the convention must be given the force of law in the Cayman Islands in order for the United Kingdom to accept our request for the convention to be extended to the Cayman Islands. This will allow for the rules of the convention and its associated protocols and regulations to govern the relevant aspects of aircraft financing, leasing, registration, and mortgaging in the Cayman Islands, and thereby fulfill our obligations as a contracting party to the convention. Part 3 of the bill includes clauses 6 to 7, as well as schedules 1 to 3, and contains provisions relating to the repeal of the 2009 law, which will replace it with this proposed legislation. And additionally, a provision is included to allow this proposed legislation to prevail over any conflicting law in the Cayman Islands for any matter governed by the convention. Madam Speaker, careful consideration has been given to the repeal of the 2009 law, and as such, the repeal will not affect any of the following items. A, the previous operation of the 2009 law, or anything duly done or suffered under the 2009 law. B, any right, privilege, obligation, or liability acquired, accrued, or incurred under the 2009 law. C, any penalty, fine, forfeiture, or punishment incurred in respect of any offense committed under the 2009 law. Or D, any investigation, legal proceeding, or remedy in respect of any such right, privilege, obligation, liability, penalty, fine, forfeiture, or punishment referred to in this section, and any such investigation, legal proceedings, or remedy which may be instituted, continued, or enforced, and any such penalty, fine, forfeiture, or punishment may be imposed as if this proposed legislation had not been passed. Madam Speaker, the bill contains schedules 1 to 3, which consist of the convention, its aircraft protocol, and the specific declarations to be made by the Cayman Islands. Madam Speaker, As the convention is an international treaty, it must be extended to the Cayman Islands by the United Kingdom. We have requested this extension of the United Kingdom. They have in turn reviewed the bill, and due to the timing issues, a number of amendments have arisen which are required to be made to the bill subsequent to the bill being published or gazetted on the 16th of January. So we will have proposals in respect of committee stage amendments. Madam Speaker, this concludes my presentation on this bill. And in closing, I would like to state that a tremendous amount of time and consideration was taken to review the convention and prepare the bill. And as such, I wish to thank very much, on behalf of government, the local Cape Town Working Group members for their efforts and their willingness to assist with this highly technical legislation. Madam Speaker, this, like many other instances where government works with the private sector, is an example of how we can work together very effectively to address the specific needs of the country, to identify particular issues that help to build the specific industries that we have, to build our economy, to make laws and institute regulations which serve the interests of the country. The time which is being spent by many members in the private sector, as well as on the government side, is significant, and we very much appreciate the level of cooperation and the level of contribution which has been made specifically in relation to this bill, but generally as well. So, again, I'd like to thank very much the Cape Town Working Group. This involved members of the Civil Aviation Authority, it involved members of the ministry, and it involved members of private sector. So their contributions have been incredible, have been very significant, have been very welcomed. Madam Speaker, with that, I therefore commend the International Interest in Mobile Equipment, brackets Cape Town Convention, close brackets, Bill 2015, to honourable members of this House for passage.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call on the Honourable Minister responsible for financial services in the event he wishes to exercise the right of reply.
Thank you, Madam Speaker. Just to acknowledge the tacit support of members of this Honourable House and thank them very much.
The question is that a bill shortly entitled the International Interest in Mobile Equipment Cape Town Convention Bill 2015 be given a second reading. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, the International Interest in Mobile Equipment Cape Town Convention Bill 2015 has been given a second reading.
The Bill of Sales Amendment Bill 2015.
Recognize the Honourable Minister for Financial Services.
Thank you very much, Madam Speaker. I beg to move the second reading of a bill entitled the Bills of Sale Amendment Bill 2015.
The bill has been duly moved. Does the Honourable Minister wish to speak to it?
Yes, thank you, Madam Speaker. Just briefly, Madam Speaker, the amendments proposed to the Bills of Sale law are driven by the anticipated extension of the Cape Town Convention to the Cayman Islands by the United Kingdom. As indicated on the earlier bill, Madam Speaker, the convention is a private law treaty that aims to standardize the transactions involving movable property, including aircraft, which utilize Cayman Islands business vehicles. And specifically, this bill proposes to add the expressions Cape Town Convention, aircraft objects, aircraft protocol, and international interests as new definitions to the Bills of Sale law, all of which are expressions which are defined under the Cape Town Convention. Now, in addition, Madam Speaker, the bill proposes to amend the definitions of bill of sale, personal chattels under the Bills of Sale law. The bill proposes to clarify that a bill of sale does not include the transfer of or assignment of any aircraft object, and that definition of personal chattels, or that the definition of personal chattels does not include international interests. Madam Speaker, as indicated previously, we have requested that the United Kingdom extend the Cape Town Convention to the Cayman Islands, subject to our passage of certain legislative amendments to ensure that local laws, such as the Bills of Sale law, are in compliance with the Convention. And accordingly, the decision to recommend that the Bills of Sale law be amended was made following extensive consultation with local aircraft finance specialists, the Civil Aviation Authority, and the Department for Business, Innovation and Skills of the United Kingdom government. The result of that consultation was the determination that the proposed amendments as set forth in this bill, Madam Speaker, are necessary. So, Madam Speaker, in conclusion, the Cayman Islands have sought to become a contracting party to the Convention, and the proposed amendments as set forth in this bill to the Bills of Sale law are a crucial part of the process to satisfy the United Kingdom that the Cayman Islands is fully prepared to become a compliant contracting party to the Cape Town Convention. I therefore commend the Bills of Sale Amendment Bill 2015 to this Honourable House for passage. Thank you, Madam Speaker.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call on the Honourable Minister for Financial Services to respond.
Thank you, Madam Speaker. Just to acknowledge the support of members of this Honourable House.
The question is that a bill shortly entitled the Bill of Sale Amendment Bill 2015 be given a second reading. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. The Bill of Sale Amendment Bill 2015 has been given a second reading. Recognize the Honourable Minister for Financial Services again.
Thank you, Madam Speaker. Madam Speaker, I beg to move the second reading of a bill entitled the Civil Aviation Authority Amendment Bill 2015.
Duly moved. Does the Honourable Minister wish to speak to it?
Thank you, Madam Speaker. Just very briefly, I rise to present the bill on behalf of the government. It is for a bill for a law to amend the Civil Aviation Law 2005 revision and to make further provision in respect of the registration of aircraft mortgages and for incidental and connected purposes. Madam Speaker, as stated in the Memorandum of Objects and Reasons for the bill, the subject of aircraft mortgages was originally made by, the registration of aircraft mortgages was originally made possible by the Mortgaging of Aircraft Regulations 1979, which is a statutory instrument made by the then governor under the purview of the United Kingdom at a period when the subject was included in the area of civil aviation strictly reserved to the United Kingdom. To date, the Civil Aviation Authority has carried out the functions of aircraft, function of registration of aircraft mortgages pursuant to the Mortgaging of Aircraft Regulations 1979. And Madam Speaker, following consultation with the United Kingdom, the Cayman Islands proposes to enact local legislation in respect of the registration of aircraft mortgages, as has been done in other British overseas territories. And doing so will consequently give ourselves here in the Cayman Islands far greater autonomy than we have had in the past in relation to this area. So this bill, Madam Speaker, confers the function of creating and maintaining an aircraft mortgage register on the Civil Aviation Authority, the Cayman Islands, Civil Aviation Authority of the Cayman Islands, under the Civil Aviation Authority law. The bill also provides for new definitions for mortgages of aircraft and mortgage register, and will empower Cabinet to make regulations relating to the registration of aircraft mortgages, registration of mortgages of aircraft, and prescribing fees in respect of matters relating to an aircraft mortgage register. Importantly, the bill also contains a validation provision which ensures that acts carried out by persons, chiefly personnel of the Civil Aviation Authority of the Cayman Islands, in exercise of matters contemplated under the Mortgaging of Aircraft Regulations 1979, in order to preserve such acts up to the date of commencement of the proposed amendments as set forth in the bill. So there will be a validation of all such acts and a saving in respect of that. Madam Speaker, the bill is fairly concise, and I think what I've outlined is sufficient to give members clarity in respect of the provisions of the bill. And with that, I simply commend the Civil Aviation Authority Amendment Bill 2015 to this Honourable House for passage. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call on the Honourable Minister for Financial Services to respond.
Thank you, Madam Speaker. I appreciate the tacit acknowledgement and acceptance of this, support of this from members of this Honourable House.
Madam Clerk, please read the title this time around for me, please.
The Director's Registration and Licensing Amendment Bill 2015.
Honourable Minister for Financial Services.
Thank you, Madam Speaker. I beg to move the second reading of a bill entitled the Director's Registration and Licensing Amendment Bill 2015.
Honourable Minister, I think in an effort to keep the expedition train going as smooth as it is, so I omitted to put the question. The question is that a bill shortly entitled the Civil Aviation Authority Amendment Bill 2015 be given a second reading. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, the Civil Aviation Authority Amendment Bill 2015 has been given a second reading.
The Directors Regulation and Licensing Amendment Bill 2015.
Honourable Minister for Financial Services.
Thank you, Madam Speaker. I beg to move the second reading of a bill entitled the Directors Registration and Licensing Amendment Bill 2015.
The bill has been duly moved. Does the mover wish to speak thereto?
Madam Speaker, very briefly, I rise to present the bill on behalf of the government. It's a bill for a law to amend the Directors Registration and Licensing Law 2014 to make provision for an appeal to be made against the cancellation or suspension of registration and the revocation and suspension of a license, and to amend the schedule. Madam Speaker, the law was gazetted on the 21st of May 2014 and made provision for the establishment of a registration regime for directors and a licensing regime for professional directors and corporate directors of mutual funds regulated under the Mutual Funds Law 2013 revision, and persons to whom paragraphs 1 and 4 of Schedule 4 of the Securities Investment Business Law 2011 revision applies. Madam Speaker, at present, the Directors Registration and Licensing Law provides that a registered director, professional director, or corporate director with the right of appeal, provides a registered director, a professional director, or corporate director with a right of appeal to the Grand Court against the decision of the Cayman Islands Monetary Authority to revoke a license granted under the Directors Registration and Licensing Law 2014. However, at present, it does not provide the right or for the right to appeal the cancellation or suspension of registration or suspension of a license. And Madam Speaker, the bill will also update a section referred to, a section referenced in the schedule of the Directors Registration and Licensing Law 2014 as well, and add a new overseas regulatory authority to the schedule. The bill is arranged in two parts, Madam Speaker. Part 1 deals with amendments to the appeals process introduced by the bill, as outlined earlier. And specifically, the bill will provide a registered director, professional director, or corporate director with a right to appeal to the Grand Court against the decision of the Cayman Islands Monetary Authority to cancel or suspend registration or revoke or suspend a license granted under the Directors Registration and Licensing Law 2014. As mentioned previously, currently that the right does not, or the right only exists, the right of appeal only exists in relation to the revocation of licenses. Part 2 of the bill, Madam Speaker, deals with amendments to the schedule of the law. The changes to the schedule, Madam Speaker, are designed to reference the correct section of the Directors Registration and Licensing Law 2014 and to add the Jersey Financial Services Commission to the list of overseas regulatory authorities contained in the schedule. Madam Speaker, these are relatively minor changes, and with that, I hope members have a sufficient indication of the effects of this bill. and I therefore commend the Director's Registration and Licensing Amendment Bill 2015 to this Honourable House for passage. Thank you.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call again on the Honourable Minister for Financial Services to respond.
Thank you, Madam Speaker. Again, just to acknowledge the tacit support of members for this Honourable House, which is appreciated very much.
The question is that a bill shortly entitled the Director's Registration and Licensing Amendment Bill 2015 be given a second reading. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. The Director's Registration and Licensing Amendment Bill 2015 has been given a second reading.
The Immigration Amendment Bill 2015.
I recognise the Honourable Premier.
Thank you, Madam Speaker. Madam Speaker, I beg to move the second reading of a bill shortly entitled the Immigration Amendment Bill 2015.
The bill has been duly moved. Does the Honourable Premier wish to speak to the bill?
Yes, Madam Speaker, and thank you. Madam Speaker, members will recall that in 2010, a new immigration category with the title Certificate for Specialist Caregivers was introduced by the UDP administration to allow domestic helpers and certain others who were employed to care for the sick, elderly, or people with disabilities to continue working in the same capacity, notwithstanding that their term limit had expired and they were no longer entitled to be granted work permits. There were various conditions attached to this category of worker, including a condition in law that disallowed someone working with a caregiver certificate to apply for permanent residency, although they may have been here in excess of 10 years. This was an attempt to create what I would term illegal fiction, since it was doubtful that this condition would withstand a challenge in court, because essentially what it required was that the time spent in Cayman under a caregiver certificate did not amount to legal and ordinary residence for the purposes of the immigration law. That, Madam Speaker, also took us back to a time when we allowed individuals to remain here for 15 or 20 years with no ability to apply for permanent residence and have some form of security of tenure. As a country, Madam Speaker, we have moved beyond this type of behavior, and I do not believe that it was wise for us to have backtracked at that point. And so, Madam Speaker, given this particular concern, in October 2013, as part of immigration policy reform by this administration, a decision was taken to discontinue issuing new certificates for specialist caregivers, but the renewal of existing certificates was allowed to continue. I have to say, Madam Speaker, that since removing the ability to issue new caregiver certificates, we on this side have received many appeals to reinstate it, given the need, and I'm confident the opposition has had similar petitions. And so, Madam Speaker, when the Leader of the Opposition brought his private member's motion in September last year, the government was minded to support it, albeit on firmer legal and moral footing than the original amendment. But there are other reasonable conditions that we believe should apply. The reestablishment of the certificate will allow workers to stay up to 10 years beyond the end of their normal term limit on residence in the islands, so long as they are still caring for the same individual. As indicated, Madam Speaker, the current immigration law allows those in specialist care occupations to stay in Cayman long enough to apply for permanent residence, and the same will apply to new caregivers. This is the right thing to do, we believe, Madam Speaker, and everyone who remains in Cayman long enough and contributes to society should have the ability to apply for permanent residence, and if successful, to eventually go on to apply for the right to be Caymanian. But everyone must understand and realize that in doing so, they will be required to undergo the same process as anyone else who applies for permanent residence, including acquiring this sufficient number of points under what some will regard as a strict point system, and they will also be required to pay the usual fees. Madam Speaker, many of us in this chamber know the difficulty of finding a non-Caymanian nurse or domestic who's reliable and able to care for the elderly, infirm, or disabled in our families. Once we do find such a caregiver, the patient as well as the family become attached and reliant on that person and become distressed if the caregiver is rolled over, as we say. So, as I said, Madam Speaker, we in the government are sympathetic, and our struggle has been to reconcile the desire to have these persons long-term with the concerns about how they fit into our immigration regime. Under our proposal, the domestic helper who is the subject of the application for a certificate of specialist caregiver must be on their final work permit before the expiration of their term limit, or be working under permission granted following the submission of an application for permanent residence. If the final work permit or permission has expired, the application for the certificate may be made if the worker is otherwise still legally resident in the islands. If the final work permit has expired and the worker has left the islands, an application for a certificate must be made within 1 year from the date of the worker's departure. The worker's final work permit must be for employment, whether by a private employer, government, or nursing home approved by Cabinet as a domestic helper, nurse, or nanny, or in some other caregiving capacity, and must have been working in that capacity for at least 3 years immediately prior to the application. We have made adjustments to the original provisions to remove references to the final non-renewable work permit, which was removed as a facility in the October 2013 policy changes. We have also had to make a change in the immigration regulations to create an application fee for the grant of a certificate for a specialist caregiver. Those who obtain such a certificate will be able to apply for permanent residence once they have reached at least 8 years of continuous residence on the islands. The certificate for specialist caregivers adds a fourth option in the immigration regime that allows a caregiver to apply for a 5-year extension to continue working for the same family. The extension lasts only as long as the caregiver works for the same person or family, and it cannot be transferred to another individual. Also, if the elderly, sick, or disabled person dies, or if the condition of an ill or disabled individual improves, the caregiver permit would end. Ultimately, these amendments are about compassion for elderly, infirm, and disabled, giving them and their families peace of mind that their care will be continued by someone who is known to them and who helps them maintain their quality of life. What these amendments intend to do, Madam Speaker, is to show sympathy and compassion to those weakest in our society who need the special care, as well as their families, and also to those who provide the much needed assistance. Madam Speaker, before winding up my introduction to this important bill, I feel compelled to address an editorial in the Caymanian Compass of April 7th of this year. In particular, the comment made in that editorial that, quote, "The caregiver certificate is the quick and dirty way of avoiding what amounts to an immigration inconvenience for Caymanians, but it does nothing to address the underlying problem That is, that Cayman's immigration system fails to meet the needs of our country's employers and does not allow for the fair, equitable, and transparent treatment of all foreign workers, unquote. Madam Speaker, I will start by explaining to the Compass editorial board that a country's immigration laws are created to suit the unique needs of the country. Where there are specific needs for employment, then immigration policy and immigration laws will address those specifically. Countries looking for nurses will allow special conditions in immigration policy or law so as to attract and maintain nurses. In terms of the caregivers' certificates, government has identified a special need and is certainly paying heed to the needs of the employers of these individuals. And the caregiver will have the same opportunities as anyone else to apply for permanent residence. We think this is only fair. What is the editorial board suggesting? That there should be some special provision which guarantees caregivers permanent residence in a way that no other segment of the community and of people who are working on work permits have? What the new provisions that we are including will do, which the previous provision did not do, is that it will allow caregivers to have the same opportunity as any other person who is resident in the Cayman Islands for 8 years. That is the opportunity to apply for permanent residence. This is but fair, we think. But certainly not everyone will be able to remain if they are unable to qualify under the same rules that apply to everyone else. But given the editorial board's stance against government providing social employment or finding its social services budget continually rising, the editorial board must certainly appreciate that anyone we allow to remain in Cayman must be able to take care of themselves in their latter years. If they don't, then the state will have to care for them. And the editorial board, which in one breath complains about unfair treatment, will in the next breath complain about the rising government costs. In another part of the editorial, it claims that the caregiver certificate is another loophole that excuses, quote, domestic workers from all manner of standards and protections that apply across other industries, for example, mandatory pensions, recruitment provisions in the gender equality law, or salary requirements under contemplated minimum wage legislation, unquote. That, Madam Speaker, is, I think, the product, those lines are, I think, are the product of an overactive imagination on the part of the editorial board. Starting with the last first, by now the editorial board will know that it is again wrong with its comment that domestic workers would not have a minimum wage applied to them. In terms of recruitment under the gender equality law, the law does provide an exemption from Section 4.1 for households, thus allowing someone to specifically seek to hire a male or a female for a specific role in the household. But I'm not sure why the editorial board of the Compass would have an issue with this. There are many reasons why private households may wish to positively discriminate, if that's what you want to call it, in this manner. One may not want to hire a man to care for young girls, for instance. That is entirely understandable and should, we think, properly be allowed. However, what the Compass should pay attention to is that the law requires that once hired, households should not discriminate against the employee in the other areas of the law. In terms of pensions, I will concede that there still remains the exception for domestic helpers to not receive a pension. And this is something, Madam Speaker, which in the future government will have to turn its attention to. However, caregivers and domestic helpers do receive the benefit of having mandatory health insurance. But I will dwell no longer, Madam Speaker, on the Compass editorial board. Needless to say, this government is satisfied that we are more progressive in name and in deed than is the editorial board of the Compass. In wrapping up, Madam Speaker, I humbly ask the members of this Legislative Assembly to support these amendments, thereby making life a little easier for those among us who need special attention and for those who provide that gentle care. I commend the bill to all members of this Honorable House.
Does any other member? I recognize the first elected member from the District of Bordentown.
Thank you, Madam Speaker. Just to say on behalf of the many people within my district and the Cayman Islands, thanks and appreciation for the reinstitution of the specialist caregiver. I've known many people just tear your heart out, Madam Speaker, sitting down crying that their helper had gone home that they'd known for so long. I just want to say special thanks for the compassion shown by this government and understanding that when there was the slip up in the October 13 immigration guidelines, whatever, that we can now come back and make amendments for those people that may look forward now to not having to worry about that aspect of their well-being. Once again, thanks to the Premier for making the changes necessary.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call on the Honorable Premier if he wishes to exercise his right of reply.
Thank you, Madam Speaker. I just wish to extend my gratitude to all members of the House for their support, spoken and tacit, with respect to this important bill. Thank you, Madam Speaker.
The question is that a bill shortly entitled the Immigration Amendment Bill 2015 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The Immigration Amendment Bill 2015 has been given a second reading.
The Coroner's Bill 2015.
I recognize the Honorable Attorney General.
Thank you, Madam Speaker. Madam Speaker, I beg to present the second reading of a bill for a law to amend the Coroner's Law 1995 revision to clarify the types of verdict which may be given by the jury in the coroner's court and to make other minor changes to the law and for incidental and connected purposes.
The bill has been duly moved. Does the Honorable Attorney General wish to speak to the bill?
Yes, Madam Speaker, thank you. Madam Speaker, this is a fairly short bill, and it seeks to do a number of things. A, to clarify the types of verdicts which the coroner's jury will be able to return. B, to abolish the provision which requires each deposition of a witness in an inquest to be read back, signed by the coroner as well as by the witnesses. To also, Madam Speaker, repeal the existing forms and to replace them with forms that are made by the Grand Court Rules Committee, and to also simplify, Madam Speaker, the making of rules by the Grand Court Rules Committee, and of course, as the long title of the bill suggests, to make other minor consequential amendments. Madam Speaker, the Grand Court Rules Committee, which is chaired by the Honorable Chief Justice, had recommended the reform of the coroner's law generally, and this initiative was undertaken by the Law Reform Commission. In the interim, Madam Speaker, modernized rules were made because of the view of the Rules Committee that with the commencement of the Bill of Rights, these matters needed to be more streamlined to reflect contemporary procedures. Whilst the rules were being reviewed, Madam Speaker, it was felt that it was also necessary to amend the law to, among other things, clarify the types of verdicts which a jury could return. The coroner's law itself was enacted way back in 1975. And at that time, Madam Speaker, the types of verdicts which could be made were not clearly specified. Indeed, Section 12 of the 1975 law dealt with the giving of verdicts, and the wording was so wide that it appeared that any type of verdict that could be made by a coroner's court was anticipated. That section, as it then was, provided that the coroner shall record his verdict, and I quote, as to who the person was upon whose body the inquest has been held, and how and when and where he met his death, or that the cause of death was unknown, as the case may be. Quite a circuitous kind of incantation, if I might put it that way. The law, Madam Speaker, was amended in 1979 to clarify this particular provision. And it also then included a provision which would allow for a verdict to be returned by a jury to say that a person might have died by some unlawful act of another person or persons. However, Madam Speaker, a further amendment was done in 1991, and it appears that during that exercise, the clarification was again revisited and was probably made a little more confusing. Madam Speaker, as it is, there are different opinions as to whether a verdict of unlawful death can be currently returned under this law. And in order to resolve this issue, the Grand Court Rules Committee has suggested an amendment to clarify the types of verdicts that can be returned. And Madam Speaker, as a result of that, the bill before this House seeks to amend Section 6 of the law to provide that the verdict of the jury shall state the following. A, the name and description of the deceased. B, when the deceased came to his death. C, where the deceased came to, the cause and circumstances of the death, and also when the deceased came to his death. So just for clarity, Madam Speaker, the name and description of the deceased person, when and where the deceased came to his or her death, and the causes and the circumstances of such death. Madam Speaker, it is felt that the above wording would permit a wider range of verdicts than those which currently exist under the law. Another proposed amendment to note is the repeal of Section 9.2 of the law, which requires that each deposition of a witness in an inquest should be signed by the coroner and also by the witness. Madam Speaker, the current arrangement is that once a witness gives evidence or deposed in an inquest, the coroner has to then read back the deposition to the witness, and both the witness and the coroner are required to sign. And so it is proposed that there will no longer be any need for this, and that instead witness statements will be relied on. The bill also seeks, Madam Speaker, by Clause 7, to slightly change the way the rules are made by now dispensing with the requirement for it to go to Cabinet, given that they are not the usual regulations and are in fact judicial procedural matters which Cabinet would not necessarily be too familiar, with which Cabinet would not necessarily be too familiar, and probably would have very little interest in any event. And so it is therefore felt that the Grand Court Rules Committee is best placed to treat with these matters. Madam Speaker, the bill also provides that the forms that are currently being used need to be upgraded And so the bill has a transitional provision which allows for the current forms to continue to be used until they're replaced by more modern forms. Finally, Madam Speaker, it is hoped that with these amendments, together with the revised coroner's rules, that greater efficiency will be realized going forward in dealing with matters in the coroner's court. Indeed, our coroners continue to do an excellent job, and it is important that they be given the necessary tools to perform their job in the usual efficient way. I certainly, Madam Speaker, wish to commend them and indeed the entire judiciary for their dedication and professionalism, not just coroner's matters, but generally. And accordingly, Madam Speaker, I commend this short bill to all honorable members of this House and seek their support, therefore.
Does any other member wish to speak? Does any other member wish to speak? Final call. Does any other member wish to speak? If not, I'll call on the Honorable Attorney General if he wishes to exercise a right of reply.
Thank you, Madam Speaker. Nothing more than to say that I certainly appreciate the support of honorable members. Thank you.
The question is that a bill shortly entitled the Coroner's Amendment Bill 2015 be given a second reading. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, the Coroner's Amendment Bill 2015 has been given a second reading. The House will now go into committee to consider the various bills. Please be seated. The House is now in committee. With the leave of the House, may I assume that, as usual, we authorize the Honorable Attorney General to correct minor printing errors and as such in the various bills. Will the clerk state each bill and read its relevant clauses?
The Proceeds of Crime Amendment Bill 2015, Clause 1, short title. Clause 2, Amendment of Section 5 of the Proceeds of Crime Law 2014 Revision, Anti-Money Laundering Steering Group.
If the Honorable Minister, were you going to say something? Okay. The question is that clauses 1 and 2 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 and 2 now stands part of the bill.
A bill for a law to amend the Proceeds of Crime Law 2014 Revision to include the chief officer in the ministry responsible for financial services, or for the chief officers designate as a member of the Anti-Money Laundering Steering Group, and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
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 Those against, no. The ayes have it. The title now stand part of the bill.
The International Interest in Mobile Equipment Cape Town Convention Bill 2015, Clause 1, short title and commencement.
The question is that clause 1 stand part of the bill? All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 1 now stand part of the bill.
Clause 2, interpretation.
Honourable Minister, I believe you have some amendments to clause 2.
Yes, thank you, Madam Chair. Madam Chair, in accordance with the provisions of Standing Order 52(1) and 2, I, the Honourable Minister of Financial Services, Commerce and Environment, give notice to move the following amendments to the International Interest in Mobile Equipment, Cape Town Convention Bill 2015. The amendment proposed in respect of Clause 2, Madam Speaker, is that firstly, in the definition of the word declaration, by deleting the word government and substituting the words United Kingdom in respect of the islands. Secondly, by inserting after the definition of the word declarations, the following definition. International interest has the same meaning as in the convention. Thirdly, by deleting the word and appearing at the end of the definition of the word protocol, and fourthly, by inserting after the definition of the word protocol the following definitions. Protocol regulations means regulations made or approved by the supervisory authority pursuant to the protocol. Second definition to be added is supervisory authority means in respect of the protocol the supervisory authority referred to in Article 17(1) of the Convention, semicolon and.
The amendment has been duly moved. Does the member wish to speak any further to it? Does any other member wish to speak? Does the mover wish to reply?
Madam Chair, thank you. I'd be happy to address any questions, but apparently there are none, so we can move on. Thank you.
I will put the question that the amendment stand part of clause 2. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. I now put the question that clause 2 as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. According to clause 2 as amended now stand part of the bill.
Clause 3, treated to have the force of law.
Recognize the Honourable Minister for his amendment to clause 3.
Madam Chair, I move an amendment in respect of the bill to add a clause 3A. So, perhaps with your guidance, should we be approving clause 3 first and then inserting 3A?
Honourable Minister, you can proceed with the proposed 3A because in effect this will be a new clause.
Thank you, Madam Chair. The proposal which I would move, or the amendment which I would would move is to insert after clause 3 the following clause. Protocol regulations. This would be 3A1. Registration of an international interest or other matter in accordance with the convention has effect for the purposes of this law only if and to the extent that it complies with the provisions of Articles 18 to 20 of the convention, brackets, registration requirements, semicolon, validity and time of registration, semicolon, consent to registration, close brackets, as modified by Article Roman 20 of the Protocol and by Protocol regulations. Subparagraph 2, the effect of registration is subject to the obligations imposed under Article 25 of the Convention, brackets, discharge of registration, close brackets, as modified by Article Roman 20 of the Protocol and by Protocol regulations, and holders of interest, intending creditors or assignees, and persons in whose favor an incorrect or erroneous registration has been made shall comply with these or with those obligations.
The amendment has been duly moved. Does any member wish to speak to the amendment? If no member wishes to speak, does the Minister of Finance? If no member wishes to speak, then I'll ask the Honourable Minister for Financial Services if he wishes to add anything further.
Thank you, Madam Chair. Just for clarity, Madam Chair, we will be approving Clause 3 first and then approving the amendment. 3A, the insertion of 3A. Thank you. Nothing further to add.
Okay. The question is that Clause 3 stand part of the bill? All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. Clause 3 now stands part of the bill. The question is that Clause 3A stand part of the bill? All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the, Clause 3A now stands part of the bill.
Clause 4, Cabinet may amend or revoke the declaration. Clause 5, the relevant court. Clause 6, repeal of Cape Town Convention Law 2009, Law 5 of 2009.
The question is that clauses 4, 5, and 6 stand part of the bill. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 4, 5, and 6 now stand part of the bill.
Clause 7, conflict with other laws.
Honourable Minister, there's an amendment, Clause 7.
Yes, Madam Chair, thank you very much. Madam Chair, I move again to propose an amendment to Clause 7 by deleting the word to and substituting the words subject to Section 8, to, as it appears therein.
The amendment has been duly moved. Does any member wish to speak to it? I put the question that the amendment stand part of the clause. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. The amendment now stands part of the bill. I put the question that clause 7 as amended now stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clause 7 as amended now stand part of the bill. Honorable, sorry, Madam Clerk.
Additional 8.
New Clause 8, Transitional Provisions.
Honorable Minister.
Madam Chair, thank you. Madam Chair, I propose, I move an amendment to the bill by inserting after clause 7, the following clause with the note transitional provisions. 8, this law does not apply to a pre-existing right or interest which retains the priority it enjoyed under the laws of the Cayman Islands before the coming into force of this law.
The question is that this clause be read a second time. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The clause is deemed to have been read a second time. The question is that this clause be added to the bill and that the subsequent clauses be renumbered accordingly. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it.
Schedule 1, Convention on International Interests in Mobile Equipment. Schedule 2, Protocol to the Convention.
The question is that Schedules 1 and 2 be added to the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Schedules 1 and 2 are now part of the bill, stand part of the bill.
Schedule 3, Declarations.
Honorable Minister, there's an amendment to Schedule 3.
Yes, thank you, Madam Chair. Madam Chair, I move an amendment to the bill by deleting Schedule 3 entirely and substituting the following schedule, headed Schedule 3, Declarations lodged by the United Kingdom in respect of the Cayman Islands under the Cape Town Convention, brackets the convention, close brackets, at the time of the deposit of the instrument of ratification by the United Kingdom in respect thereof. The United Kingdom of Great Britain and Northern Ireland is to make the following declarations in respect of the Cayman Islands pursuant to the convention and the protocol to the convention on matters specific to aircraft equipment. In these declarations, new paragraph, in these declarations, the phrase, quote, government of the Cayman Islands, close quote, means any public or governmental body, including any statutory body or company or association in which the Cayman Islands has an interest and which performs a public function or duty, and any entity that provides any public function or duty for on behalf of the government of the Cayman Islands, and includes, without limitation, the Civil Aviation Authority of the Cayman Islands and the Cayman Islands Airports Authority. Full stop. Next, paragraph 1, declaration headed Declarations pursuant to Article 339, subarticle 1 of the Convention. Subparagraph A, that all categories of non-consensual rights or interests which, under the laws of the Cayman Islands at the date of this declaration, or created after that date, have priority over an interest in an object equivalent to that of the holder of a registered international interest, shall, to that extent, have priority over a registered international interest, whether in or outside insolvency proceedings. subclause B, that nothing in the convention shall affect the right of the government of the Cayman Islands or any other provider of public services, brackets, whether an intergovernmental organization or a private or public entity or otherwise, close brackets, to arrest or detain an aircraft object under the laws of the Cayman Islands for payment of amounts owed to such entity, organization, or provider directly relating to those services in respect of that aircraft object or another aircraft object. Second paragraph, headed Declaration pursuant to Article 39, Subarticle 4 of the Convention, declares that a right or interest of a category covered by a declaration made under paragraph 1A above, pursuant to Article 39 1A of the Convention, shall have priority over an international interest registered prior to the date of deposit of the United Kingdom of Great Britain and Northern Ireland's instrument of ratification. Paragraph 3, headed Declarations pursuant to Article 53 of the Convention, that the relevant court, quotes around court, for the purposes of Article 1 and Chapter Roman 11 of the Convention is the Grand Court of the Cayman Islands. Paragraph 4, headed Declaration pursuant to Article 54, Subarticle 2 of the Convention, that all remedies available to the creditor under any provision of the Convention or Protocol which are not expressed to require application to the court may be exercised without leave of the court. Full stop. Paragraph 5, headed Declarations pursuant to Article Roman 31 of the Protocol. A, that it will apply Article 8, Roman 8 of the Protocol. B, that it will apply Article Roman 12 of the Protocol. And C, that it will apply Article Roman 13 of the Protocol. Paragraph 6, headed Declaration pursuant to Article Roman 30, brackets 2, Subarticle 2 of the Protocol, that it will apply Article Roman 10 of the Protocol in its entirety, and that the number of days to be used for the purposes of the time limit laid down in Article Roman 10.2 of the Protocol shall be 10 working days in the Cayman Islands from the date the application for relief is filed. Paragraph 7, headed Declaration pursuant to Article Roman 30, Subarticle 3 of the Protocol, that it will apply Article Roman 11, Alternative A of the Protocol in its entirety to all types of all insolvency proceedings, and that the waiting period for the purposes of Article Roman 11.3 of that alternative shall be 60, bracket 60, number 60, calendar days. Close quote, full stop.
The amendment has been duly moved. Does any member wish to speak to it? If not, I put the question that the amendments of the schedule stand part of the, that the amendments stand part of the schedule. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The amendment stands part of the schedule. I put the question now that the schedule as amended stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The schedule as amended now stands part of the bill.
A bill for a law to repeal and replace the Cape Town Convention Law 2009 to give effect to the Convention on International Interest in Mobile Equipment and the protocol thereof on matters specific to aircraft equipment concluded at Cape Town, South Africa on 16 November 2001, and the declarations made by the Cayman Islands in respect thereof and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. This title now stand part of the bill.
The Bill of Sale Law Amendment Bill. The Bills of Sale Amendment Bill 2015. Clause 1, short title and commencement. Clause 2, amendment of Section 2 of the Bills of Sale Law 2000 revision, definitions and interpretation.
The question is that clauses 1 and 2 stand part of the bill. All those in favor, please say aye.
Aye.
Against, no. The ayes have it. Clauses 1 and 2 now stand part of the bill.
A bill for a law to amend the Bills of Law Sale 2000 revision to exclude bills of sale over aircraft objects from the scope of the principal law and to make provisions for incidental and connected matters.
The question is that the title now stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title now stand part of the bill.
The Civil Aviation Authority Amendment Bill 2015, Clause 1, short title and commencement. Clause 2, amendment of Section 2 of the Civil Aviation Authority Law 2005 revision, definitions. Clause 3, amendment of Section 5, functions of authority. Clause 4, amendment of Section 39, regulations. Clause 5, validation.
The question is that clauses 1, 2, 3, 4, and 5 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, clauses 1, 2, 3, 4, and 5 now stand part of the bill.
A bill for a law to amend the Civil Aviation Authority Law 2005 revision to make further provision in respect of the registration of aircraft mortgages and to make provision for incidental and connected matters.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title now stand part of the bill.
The Director's Registration and License Amendment Bill 2015, Clause 1, short title. Clause 2, amendment of Section 27 of the Director's Registration and Licensing Law 2014, Law 10 of 2014, appeals. Clause 3, amendment of the schedule of the Director's Registration and Licensing Law 2014, Law 10 of 2014, list of overseas regulatory authorities.
The question is that clauses 1, 2, and 3 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1, 2, and 3 now stand part of the bill.
A bill for a law to amend the Director's Registration and Licensing Law 2014, Law 10 of 2014, to make provision for an appeal to be made against a cancellation or suspension of registration and for the revocation and suspension of a license, and to amend the schedule and for incidental and connected purposes.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title now stand part of the bill.
The Immigration Amendment Bill 2015, Clause 1, short title. Clause 2, amendment of Section 2 of the Immigration Law 2014 revision, definitions. Clause 3, repeal and substitution of Section 37C, certificate for specialist caregiver Clause 4, amendment of section 114, transitional provisions.
The question is that clauses 1, 2, 3, and 4 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1, 2, 3, and 4 stand part of the bill.
A bill for a law to amend the immigration law 2014 revision to revise immigration policy as it relates to specialist caregivers and to make provision for incidental and connected matters.
The question is that the title stand part of the bill. All those in favor, please say aye.
Aye. Aye.
Those against, no. The ayes have it. The title now stand part of the bill.
The Coroner's Amendment Bill 2015. Clause 1, short title and commencement. Clause 2, amendment of section 6 of the Coroner's Law 1995 revision, the jury. Clause 3, amendment of section 9, recording of evidence at an inquest. Clause 4, amendment of section 11, intervention by the Director of Public Prosecutions. Clause 5, amendment of section 14, proceeding upon inquisition charging any person with a criminal offense. Clause 6, repeal of section 22 and replacement forms. Clause 7, amendment of section 24, rules. Clause 8, repeal of the schedule. Clause 9, transitional provisions.
The question is that clauses 1, 2, 3, 4, 5, 6, 7, 8, 9 stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Clauses 1 through 9 now stands part of the bill.
A bill for a law to amend the Coroner's Law 1995 revision to clarify the types of verdicts which may be given by the jury in a coroner's court and to make other minor changes to the law and for incidental and connected purposes.
The question is that the title now stand part of the bill. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The title now stand part of the bill. The question is that the bills be reported to the House. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. The House will now resume. Please be seated. The House has now resumed.
Report on bills. The Proceeds of Crime Amendment Bill 2015.
I recognize the Honourable Minister responsible for financial services.
Madam Speaker, I have to report that a bill shortly entitled
Is set down
The
for the third reading.
sorry,
Is set down for the third reading.
we're not reporting the committee.
The bill has been duly report to the committee. Go ahead, please.
Right, sorry. That a bill shortly entitled the Proceeds of Crime Amendment Bill 2015 was considered by a committee of the whole House and passed without amendment.
The bill has been duly reported and is set down for its third reading. I recognize now the Honourable Premier. We've reached the hour 4:30 to move the suspension of Standing Order 10-2 to allow business continue beyond that hour.
Madam Speaker, I beg to move the suspension of Standing Order 10-2 in order that the business of the House may continue beyond the hour of interruption.
The question is that Standing Order 10-2 be hereby suspended to allow the business of the House to continue beyond the hour of interruption. All those in favor, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, Standing Order 10-2 is hereby suspended. Please continue.
The International Interest in Mobile Equipment, Cape Town Convention, Bill 2015.
Recognize the Honourable Minister for Financial Services.
Madam Speaker, I am to report that a bill shortly entitled the International Interest in Mobile Equipment, brackets Cape Town Convention, Bill 2015, was considered by a committee of the whole House and passed with amendments.
Thank you. The bill has been duly reported and is now set down for its third reading.
The Bill of Sales Amendment Bill 2015.
Honourable Minister for Financial Services.
Madam Speaker, I'm pleased to report that a bill shortly entitled the Bills of Sale Amendment Bill 2015 was considered by a committee of the whole House and passed without amendment.
The bill has been duly reported, is set down for its third reading.
The Civil Aviation Authority Amendment Bill 2015.
Honourable Minister for Financial Services.
Thank you, Madam Speaker. I'm pleased to report that a bill shortly entitled the Civil Aviation Authority Amendment Bill 2015 was considered by a committee of the whole House and passed without amendment.
The bill has been reported and is now set down for its third reading.
The Directors Registration and Licensing Amendment Bill 2015.
The Honourable Minister responsible for Financial Services.
Thank you again, Madam Speaker. I have to report that a bill shortly entitled the Directors Registration and Licensing Amendment Bill 2015 was considered by a committee of the whole House and passed without amendment.
The bill has been reported and is now set down for its third reading.
The Immigration Amendment Bill 2015.
I recognize the Honourable Premier.
Thank you, Madam Speaker. Madam Speaker, I am to report that a bill shortly entitled the Immigration Amendment Bill 2015 was considered by a committee of the whole House and passed without amendment.
The bill has been duly reported, is now set down for its third reading.
The Coroner's Amendment Bill 2015.
Recognize the Honourable Attorney General.
And thank you, Madam Speaker. Madam Speaker, I beg to report that the bill with a short title, the Coroner's Amendment Bill 2015, was considered by a committee of the whole House and passed without amendment.
This bill has been duly reported and is now set down for its third reading. Third readings. Honourable Premier, are you going to continue on or are you going to adjourn for tomorrow? If not, I'll have the motion for adjournment. If not, going to do a suspension. Can we have an adjournment motion, please?
Thank you, Madam Speaker. Madam Speaker, I wish to commend all members of the House and indeed the staff for the efficient way in which the business of the House has been conducted today. We've gotten through all of the government bills, through all of the stages we could possibly go through today without suspending standing order with respect to the third reading. And so we are at the end of the order paper for the day. And I therefore move the adjournment of this Honourable House until 10 a.m. tomorrow morning, when we will deal with the third reading and proceed with the private members' motions.
Thank you. The question is that the Honourable House be adjourned until 10 a.m. tomorrow morning. All those in favour, please say aye.
Aye.
Those against, no. The ayes have it. Accordingly, this Honourable House now stands adjourned until 10 a.m. tomorrow morning.